Chapter 23, Securities Regulation, presented by Kelly Herzik. I want to point out something about your textbook concerning this chapter. It has not been updated, so many of the statements, particularly about penalty amounts and even some statements about sections in the relevant securities laws, are wrong. Sometimes this happens where a textbook is not updated timely before it's printed. I corrected the important issues in the slides, so if there's a conflict between the text and these slides, rely on the slides for the most current information, much of which I confirmed from information and materials from the SEC directly. In this lesson, we will cover securities, securities regulation, the Securities Act of 1933, the Securities Exchange Act of 1934, regulation of investment companies, and state securities laws. As you will see in this lesson, the core of securities regulation was passed in 1933 and 1934 during the Great Depression. We will begin with securities law in general. Companies frequently need to raise money, and one way to do that is to issue securities. As you may recall, corporations raise money either by issuing debt securities like bonds or equity securities like stock. A security is a financial instrument designated as a note, stock, or bond, or any other instrument named in the Securities Act of 1933. Securities have no intrinsic value. They're just paper. Without securities regulations, corporations could easily commit fraud by issuing large numbers of securities and then refusing to pay for them. To prevent fraud, the government heavily regulates securities, both in their issuance and trading. Prior to the stock market crash in 1929, the government did not regulate securities. While a security is literally a piece of paper, investors buy securities for what that piece of paper represents, and that is where the value is in a security. Besides stocks and bonds, securities can include notes, investment contracts, rights in oil and gas leases, debentures, and warrants, to name some examples. There have been some courts that have concluded that cosmetics, vacuums, and cemetery plots are included in the definition of securities. The reason so many items have been determined to be securities lies in the complex definition of a security in the Securities Exchange Act of 1933. I'm not going to reproduce it here. It's literally a paragraph and a half long. In 1985, in the case of Landreth versus Landreth Timber Company, the Supreme Court stated that courts should presumptively treat as a security any financial instrument designated as a note, stock, bond, or other instrument named in the 1933 Act. If it does not meet the definition under the 1933 Act, courts apply a three-part test to determine if an instrument is a security. It must be an investment in a common enterprise with a reasonable expectation of profit and primarily from others' efforts. This is called the Howey test. Under Howey, a security is a monetarily passive investment without managerial control over the investment. The definition of a security is actually a complex question under security law. It's heavily litigated. The definition in the Securities Act of 1933 is actually a large paragraph and a half long, as I mentioned. And the definition is nearly the same in the Securities Exchange Act of 1934. The definitions are substantially similar and are not intended to be treated differently in the application of either act. It was the congressional intent that the definition of security be very broad to encompass all forms of investment instruments and contracts that may be used in the commercial world. Next, we will discuss securities regulation. There are two major Great Depression era statutes that regulate securities transactions in the U.S. and seek to provide greater stability to securities transactions. The Securities Act of 1933 regulates how companies issue corporate securities. The Securities Exchange Act of 1934 oversees the purchase and sale of securities. These statutes mandate that investors must have access to particular information when deciding on whether to buy or sell securities. These acts also seek to prevent fraudulent securities transactions. The 1934 Act created the Securities and Exchange Commission, which I will reference heavily as the SEC, which is a federal agency that administers and enforces federal securities law. Next, we will discuss some information about the SEC. According to the SEC, it protects investors, promotes fairness in the securities markets, and shares information about companies and investment professionals to help investors make informed decisions and invest with confidence. The SEC is headed by 5 individuals that are appointed by the President, who serve for staggered 5-year terms, and no more than 3 commissioners can be from the same political party. The SEC is responsible for the enforcement of securities laws, and if there is an allegation of securities law violation, the SEC investigates and, if needed, instigates an enforcement action. Typical infractions include insider trading, accounting fraud, and providing false or misleading information about securities and the companies that issue them. In enforcement actions initiated by the SEC, remedies can involve monetary penalties and injunctive options to prohibit future malfeasance. In addition to civil penalties, if the violation is severe, criminal charges can be brought, though the Department of Justice, in its fraud section of the Criminal Division, will handle the prosecution, not the SEC. The SEC interprets securities laws and issues and revises rules to achieve the purposes of the Securities Acts. The SEC oversees the inspection of securities firms, brokers, investment advisors, and ratings agencies. The SEC regulates the activities of securities brokers, dealers, and advisors. All securities brokers, dealers must register with the SEC. The SEC oversees private regulatory organizations in the securities, accounting, and auditing fields. And the SEC regulates the trade of securities on securities exchanges. Next, we will discuss the Securities Act of 1933. The Securities Act of 1933 was passed in reaction to the mistrust of securities transactions undertaken before the Great Depression. These transactions led to the great stock market crash in 1929. Often referred to as the Truth in Securities Law, the Securities Act of 1933 has 2 basic objectives. It requires that investors receive financial and other significant information concerning securities being offered for public sale, and it prohibits deceit, misrepresentations, and other fraud in the sale of securities. The Act requires the disclosure of important financial information through the registration of securities. A function of the Act was to legitimize security transactions by requiring the registration of securities offered to the public, and through registration, investors have more information to make informed decisions about securities purchases. This information enables investors, and not the government, to make informed judgments about whether to purchase a company's securities. While the SEC requires that the information provided be accurate, it does not guarantee it, meaning that information in the registration must be accurate, but it's not guaranteed by the SEC. Investors who purchase securities and suffer losses have important recovery rights if they can prove that there was incomplete or inaccurate disclosure of important information. Section 5 of the 1933 Act mandates that any corporation, partnership, association, or individual that offers the sale of securities to the public through the mails or other means of interstate commerce must register that security, though there are some exceptions to the registration, and we will discuss those later. Any issuer of securities must file a written registration statement and a prospectus with the SEC. The SEC has stated that the registration forms companies file provide essential facts while minimizing the burden and expense of complying with the law. Next, we will discuss the registration statement and its content. Although the SEC requires different types of companies to complete slightly different registration forms, the SEC requires some core information in every registration statement: a description of the securities offered for sale, an explanation of how proceeds from the sale of securities will be used, a description of the registrant's business and property, information about the management of the company, a description of any lawsuit in which the registrant is involved, and financial statements certified by an independent public accountant. All companies, domestic and foreign, must file the registration form electronically with the SEC. Registration statements and the accompanying prospectus become public shortly after filing, and investors can access them using EDGAR, the SEC's search engine. Registration statements are subject to examination for compliance with disclosure requirements. Next, we will discuss the accompanying prospectus. Along with the registration, any company or individual listing securities for sale must also file a prospectus with the SEC. A prospectus is a written document that contains a description of a security and other financial information regarding the company offering the security. A prospectus is also often used as an advertising tool for prospective buyers to rely on when deciding on whether to purchase the security. In actuality, it contains most of the information contained in the registration form required by the SEC. As with the registration form, the SEC only requires the information in the prospectus to be accurate, but it does not guarantee the information. If there are false or misleading statements, the company can be subject to civil or criminal penalties. Next, we will discuss the periods of filing during the registration process. The filing process consists of 3 periods: pre-filing, waiting, and post-effective. The pre-filing period runs from when the issuer starts to think about offering securities through when the issuer files the registration form and prospectus with the SEC. Before filing the registration form and prospectus, an issuer cannot make any offers to sell securities. However, an issuer can negotiate with underwriters, which is an investment bank that purchases securities to sell at a brokerage house, which then sells them to the public. During this time period, companies usually do not advertise or seek publicity about any upcoming security sales because the SEC might construe the publicity as an attempt to create interest in the securities. The SEC could interpret any speeches or press releases mentioning the potential issuance of the securities to be an offer. The issuer is permitted to publish a notice about the prospective offer with a description of the potential securities, but may not include the name of the underwriter. After the pre-filing period is the waiting period. Once the registration form and prospectus are filed with the SEC, the waiting period begins. During this time, the SEC reviews the information filed, and issuers must wait 20 days after the filing date to sell their securities. During the waiting period, issuers may make oral offers to sell the securities and may distribute a red herring prospectus. A red herring prospectus contains a warning written in red print at the top of the page, warning investors that the registration has been filed with the SEC but not yet approved. The issuer can also issue what they call a tombstone advertisement, which is a brief ad with a format similar to a tombstone that announces the upcoming security offering. Then there is the post-effective period. This begins when the SEC approves the registration filings as effective and ends when the securities are sold or withdrawn from sale. During this time, investors can buy and sell securities, but any purchaser must receive a final prospectus, and if they do not, it's a violation of the 1933 Act. Next, we will discuss exemptions under the 1933 Act. Not all security sales must be registered with the SEC. Some sales are exempt because of the nature of the securities themselves, exempt securities, and others are exempt when exchanged in certain ways. These are exempt transactions. Exemptions to the securities registration requirement include private offerings to a limited number of persons or institutions, offerings of limited size, intrastate offerings, and securities of municipal, state, and federal governments. By exempting many small offerings from the registration process, the SEC seeks to foster capital formation by lowering the cost of offering these types of securities to the public. There is a more complete list of exempt securities, known as unregistered, unrestricted securities, listed on the bottom of page 508 to the top of page 509 in your textbook, though there is an issue with number 10. It says up to $5 million in your book, but the cap is actually $50 million in a 12-month period. These small offerings are covered by Regulation A, issued by the SEC. Regulation A is an exemption from registration for public offerings. Regulation A has two offering tiers. Tier 1 for offerings up to $20 million in a 12-month period, and Tier 2 for offerings up to $50 million in a 12-month period. Companies using Regulation A must still file offering statements with the SEC and provide an offering circular similar to a prospectus. However, Regulation A registration is simpler and less burdensome than the full registration process. There are certain basic requirements applicable to both Tier 1 and Tier 2 offerings, including company eligibility requirements, bad actor disqualification provisions, disclosure, and other matters. Next, we will discuss exempt transactions. If a security does not fall within an exemption, an issuer can still avoid registering the security by making certain exempt transactions. These securities are unregistered but restricted securities, though issuers must still provide investors with information about the securities, such as annual reports and financial statements. These exempt transactions include limited offers, intrastate issues, and resales of securities. Let's talk about limited offers. These are exempt from registration because they either involve small amounts of money or are offered only to sophisticated investors who do not usually need the protection afforded by the registration process. They're governed by Regulation D. Regulation D enumerated 3 exceptions for limited offers under Rules 504, 505, and 506. However, 505 was repealed in 2016 and basically collapsed into 504. In your book, it still lists 505 as an active section, but it was repealed in 2016. So you're going to have to ignore what's in your book for a little while as I talk about these 3 sections in Regulation D because of the way that Section 505 was folded into Section 504. Then there is Section 4-6 of the 1933 Act, which contains an additional limited offer exemption. First, we will discuss private placement exemptions under Rule 506. Issuers that make private offers are exempt from registration. Issuers cannot advertise private offers to the general public. The private placement exemption allows companies to issue an unlimited number of securities to an unlimited number of what they call accredited investors. Accredited investors are private investors who are allowed to accept private securities offerings under certain specific guidelines set by the UCC. The SEC defines an accredited investor as a natural person who has a net worth of at least $1 million, a natural person whose annual income has been at least $200,000 for the 2 years previous and expects to make at least $200,000 in the current year, a corporation or partnership with total assets in excess of $5 million, an insider of the issuer, such as an executive officer or director, or a registered investment company, college, university, bank, or insurance company. These are all accredited investors under the SEC definition. Firms may not issue to more than 35 unaccredited investors and must believe that these unaccredited investors have expertise regarding securities trading and have the ability to assess the risks associated with the purchase of the securities. If all the investors are accredited investors, then the issuer does not have to provide any information to investors or register the securities, but they do have to notify the SEC of any sales made under this exemption. If the investors are unaccredited, they do have to give basic information to investors. These private offerings are ideal for raising capital. As I mentioned before, Rule 505 was repealed by the SEC effective October 26, 2016. It previously provided an exemption for offers and sales of securities totaling up to $5 million in any 12-month period. Under this exemption, securities could be sold to an unlimited number of accredited investors and up to 35 unaccredited investors. The Rule 505 exemption was phased out and its provisions integrated into the Rule 504 exceptions. Rule 504's capital limit increased to $5 million, and Rule 505's bad actor provision was added to Rule 504. So let's talk about Rule 504. It provides an exemption for the offer and sale of up to $5 million of securities in a 12-month period. Some companies are not eligible to use this exemption, such as companies that already are Exchange Act reporting companies, investment companies, and companies that are disqualified under Rule 504's bad actor disqualification provisions. They must give notice to the SEC of sales within 15 days of the first sale. Under 504, the issuer can sell to both accredited and unaccredited investors without limit. Investors do not have to give any information to investors under this section. Rule 504 offerings are subject to the disqualification provisions found in Rule 506 of Regulation D. The bad actor disqualification provisions disqualify offerings if the issuer or other covered person have experienced a disqualifying event, such as being convicted of or sanctioned for securities fraud or other violations of specified laws. The last limited offering exemption is located in Section 4-6 under the 1933 Act. Under that act, if a firm offers securities up to $5 million only to accredited investors, the issuer is exempt from registration with the SEC. The definition of accredited investors are the same as in the rules we just discussed. Only accredited investors may participate in these offerings, and the number is unlimited. Issuers cannot advertise these offerings with the public. No information is required to be given to investors, but they must give notice to the SEC of sales under this exemption. Investors who want to resell these securities must register them with the SEC. Next, we will discuss intrastate issues. Under Section 3 of the 1933 Act, any security offered or sold to a permanent resident of a single state where the issuer resides and is doing business is exempt. This is covered in Rules 147 and 147A issued by the SEC. Local companies can rely on local investors to raise capital without a cap on the amount and without registering with the SEC. For at least 6 months after the sale, buyers cannot resell these securities to non-residents, and if they do resell them, they must register sales with the SEC. In order to use the intrastate exemption, issuers conducting an offering pursuant to Rule 147 or Rule 147A must satisfy at least one of the following requirements in order to be considered doing business in a state. The issuer derives at least 80% of its consolidated gross revenues from the operation of a business in-state. The issuer has at least 80% of its consolidated assets located in-state. The issuer intends to and uses at least 80% of the net proceeds from the offering towards the operation of a business in state, or a majority of the issuer's employees are based in state. Next, we will discuss resales. The 1933 Act creates exemptions for transactions by persons other than an issuer, underwriter, dealer, or broker. Only issuers and underwriters are not exempt from registering resales of securities. This means that the average investor does not have to register securities when he or she wants to sell. If the investor acquired them through sales under 504, 506, or Section 4-6, meaning as intrastate securities or limited offers, they are restricted securities. Restricted securities are securities acquired in unregistered private sales from the issuing company or from an affiliate of the issuer. Investors typically receive restricted securities through private placement offerings, Regulation D offerings, employee stock benefit plans, as compensation for professional services, or in exchange for providing startup capital for the company. Restricted securities are securities that have limited transferability and are usually issued in a private placement. To resell these to the public, an investor has to register them unless they follow Rule 144 or 144A. Rule 144 allows public resale of restricted and controlled securities if a number of conditions are met. The public must have access to adequate information on the issuer. The seller must have owned the security for 6 months to 1 year, depending on if the issuer was a reporting company under the 1934 Act. The seller must sell the restricted securities in limited amounts in unsolicited broker transactions, and the seller must notify the SEC of the sale. Next, we will discuss violations and liability under the 1933 Act. If the SEC finds a potential violation of the 1933 Act, it can take administrative or civil action, take injunctive action, or recommend criminal prosecutions, or all three. The Enforcement Division of the SEC performs its law enforcement function by recommending the commencement of investigations of securities law violations, by recommending that the SEC bring civil actions in federal court or before an administrative law judge, and by trying these cases on behalf of the SEC. As an adjunct to the SEC's civil enforcement authority, the division works closely with law enforcement agencies in the U.S. and around the world to bring criminal cases when appropriate. The division obtains evidence of possible violations of securities laws from many sources, including market surveillance activities, investor tips and complaints, other divisions and offices of the SEC, the self-regulatory organizations, and other securities industry sources and media reports. All SEC investigations are conducted privately. Facts are developed to the fullest extent possible through informal inquiry, interviewing witnesses, examining brokerage records, reviewing trade data, and other methods. Common violations include making a misrepresentation or omission of important information about securities, manipulating market prices of securities, stealing customers' funds or securities, violating broker-dealers' responsibility to treat customers fairly, insider trading, and selling unregistered securities. If the SEC takes administrative action, it does so under a formal order of investigation. Once a formal investigation is started, it has the power to compel witnesses by subpoena to testify and produce books, records, and other relevant documents. If the facts warrant it, the SEC can either bring a civil action in federal district court or within the SEC before an administrative law judge, or both. If the SEC files a complaint in U.S. District Court, it often seeks both monetary sanctions and an equitable remedy, such as an injunction to prohibit illegal current and future conduct, disgorgement, which is the return of illegal profits, or an order prohibiting an individual from serving as an officer or director of the company. If the SEC brings the matter before an independent administrative law judge, the judge issues an initial decision that includes findings of fact and legal conclusions and contains a recommended sanction. Administrative sanctions include cease and desist orders, suspension or revocation of broker-dealer and investment advisory registrations, censures, bars from association with the securities industry, civil monetary penalties, and disgorgement. In many cases, the SEC and the party charged decide to settle the matter without trial. In addition to civil and administrative penalties, the SEC can recommend to DOJ that a violator be criminally prosecuted. Remember, the SEC does not do the criminal prosecutions, that's the Department of Justice. Securities fraud can involve very high fines. In some situations, such as in cases of insider tradings, fines of up to $5 million are possible for individuals and non-natural persons up to $25 million. While fines or other types of securities fraud can be $10,000 or more. A conviction for securities fraud can also result in a prison sentence. Any conviction for federal securities fraud crime can result in a 5-year federal prison sentence per offense, though insider trading can be up to a 20-year prison sentence. Companies could be liable for securities fraud when they willfully violate the Securities Act of 1933. A company can violate the Act if it intentionally misleads investors by omitting or falsifying information on the registration form or in the prospectus. If a company is negligent in discovering a fraudulent statement, this can create liability as well. An issuing company can also violate the Act if it sells securities before the effective date of the registration form, and there are no defenses to this violation. It's strict liability. But there are defenses generally to violation allegations. For fraudulent statements or omissions, a company can defend by claiming the statement or omission was immaterial to the sale of the security, meaning it wasn't important. The issuer can try to prove that the buyer was aware of the false statement or omission at the time of purchase of the security to avoid liability, meaning the buyer already knew about this when they bought it. Any defendant except the issuer can raise the due diligence defense, meaning the defendant did his reasonable due diligence in investigating the registration form. In the due diligence defense, the defendant needs to show they investigated the information in the registration form and had reasonable grounds to believe the statement was accurate and had no omissions of material fact. Investors who purchase securities and suffer damages as a result of an issuer's alleged false or misleading statement or omission can bring a civil suit to recover damages. The burden of proof in a civil suit will be on the investor to prove by a preponderance of the evidence that any statement or omission was inaccurate, incomplete, or misleading. Next, we will discuss the Securities Exchange Act of 1934. The difference between the Securities Act of 1933 and the Securities Exchange Act of 1934 is this. The 1933 Act is a one-time disclosure law, whereas the 1934 Act provides for continuous periodic disclosures by publicly held corporations. The Securities Exchange Act of 1934 regulates the trading or resale of securities, primarily through registration of securities exchanges, brokers, dealers, and national securities associations. The 1934 Act also requires certain issuers to file periodic reports with the SEC and permits the SEC to monitor the securities markets for fraud and market manipulations. The 1934 Act provides a private right of action for investors to sue for securities fraud under Section 10B of the Act, but secondary actors, also known as aiders and abettors, are not reachable unless their own conduct directly satisfies each of the elements for Section 10B liability. The plaintiff generally must prove reliance in making a decision to acquire or hold a security upon a material misrepresentation or omission by the defendant. Next, we will discuss Section 10B of the 1934 Act and SEC Rule 10B-5. Section 10B of the Exchange Act of 1934 and the SEC rule interpreting it, which is known as Rule 10B-5, are powerful tools for the SEC. This section of the 1934 Act prohibits the use of manipulative and deceptive actions to bypass SEC rules. Subsection 5 of Section 10B prohibits fraud, misrepresentation, and deceit associated with the purchase or sale of all securities, even those that are exempt from SEC registration. So just because something is exempt from registration does not mean that it's exempt from fraud prosecution. It prohibits both affirmative fraudulent acts and omissions designed to deceive. SEC Rule 10B-5 is one of the most important rules targeting securities fraud and insider trading issued by the SEC pursuant to its authority granted under Section 10 of the Securities Exchange Act of 1934. Next, we will discuss a large area of SEC enforcement which deals with insider trading. Insiders are corporate officers, directors, employees, lawyers, consultants, accountants, majority shareholders, or any other individuals who receive private material information regarding the trading of securities. Insider trading is when an employee, director, or executive, or one of those parties uses inside material information to make a personal profit. Insider trading is illegal because it allows the insider an important advantage over the general public and other shareholders. Material inside information can include a change in status of litigation against the company, a change in dividends, a contract for the sale or purchase of corporate assets, a new product, process, or discovery, or a significant change in the financial status of the company, such as a merger or bankruptcy. A person who obtains material inside information cannot use it or must disclose it to all the other parties to the transaction. Next, we will discuss the Private Securities Litigation Reform Act of 1995. The Private Securities Litigation Reform Act of 1995, the PSLPA, provides a safe harbor for forward-looking statements to encourage companies to provide prospective information, so long as those statements are identified as forward-looking and are accompanied by meaningful cautionary statements identifying important factors that could cause the actual results to differ materially from those disclosed in the statement. The PSLPA protects publicly held companies that issue securities and that make financial forecasts as long as the forward-looking statement is identified as a forward-looking statement. It must be clear that a statement is a projection. The estimate or projection must also be accompanied by one or more qualifiers stating important factors why the results predicted in the forward-looking statement may not come true. The point is to identify enough factors so that the investor should realize the risks involved in relying on the forward-looking statement. You need a few weasel words in there to protect yourself from liability. Now let's talk about outsiders and insider trading. In addition to insiders like corporate officers and directors, outsiders to the company can also be liable for insider trading under two theories: misappropriation theory and tipper-tippee theory. Misappropriation theory. This theory of liability holds that if an individual wrongfully acquires or misappropriates or steals and uses insider information to trade securities for personal gain, this constitutes insider trading. Based on Supreme Court precedent, misappropriation has been clearly established as a theory of liability for insider trading under SEC Rule 10B-5. Then there's tipper-tippee theory. This theory of liability holds that an individual, the tippee, who acquires material inside information from an insider, the tipper, who breaches his duty, constitutes insider trading. Martha Stewart was convicted of insider trading based on a tip from her broker that the president of a company in which she held stock was selling his stock. So let's take a look at an example of outsiders and insider trading. Suppose Larry is a director of ABC Company. He tells his friend Betty that ABC Company is about to be bought out by big corporation, which will cause the stock price of ABC Company to rise significantly. Larry, as the insider, is the tipper, and Betty, who got this inside information from Larry, is the tippee. If Betty then acts on the tip that she should know is not public and buys more ABC stock, even though she is an outsider, she is liable for insider trading. Larry, who breached his duty to ABC, is also liable for insider trading. Larry would be liable for any profits made by Betty. Betty is liable if she knew or should have known the tip she got from Larry was not public. Next, we will discuss Section 16B of the 1934 Act and swing sales. Under Section 16 of the 1934 Act, certain large stockholders, executive officers, and directors are considered statutory insiders. All statutory insiders must file a report detailing their ownership and trading of their own corporation's securities. For example, if a president of a corporation buys shares of her corporation, she must file a notice of the purchase with the SEC. It's not illegal for the president to buy the shares, but they must give notice to the SEC of the purchase and the purchase price. However, the 1934 Act requires statutory insiders to return all short swing profits to the company. Short swing profits are profits made from the sale of company stock within any 6-month period by a statutory insiders. Section 16B imposes strict liability on statutory insiders who earn short swing profits, meaning violators cannot use lack of intent or lack of insider knowledge as a defense. Let's take a look at an example. If an officer buys 1,000 shares at $5 a share in January and sells these same shares in April for $10 per share, they would have made a profit of $5,000. Because the shares were bought and sold within a 6-month period, the officer would have to return the $5,000 to the company as a swing sale. Next, we will discuss another area of SEC regulation known as proxy solicitations. A proxy is a writing signed by a shareholder that authorizes an individual named in the proxy to vote the shareholder's shares corresponding to the number of shares of stock at the shareholders' meeting. A proxy solicitation is the process of obtaining this proxy authority to vote a shareholder's stock, usually done by corporate managers or directors. Because this process is susceptible to fraud, the SEC regulates the proxy solicitation process. Section 14A of the 1934 Act requires that an issuer making proxy solicitations must also furnish a written proxy statement to shareholders. The written proxy statement must give the shareholder all the facts pertinent to the voting that will occur at the meeting. Now I want to discuss and recap some of the violations of the 1934 Act. I've mentioned some of them previously, but I wanted to put them all in one slide for you so you'd have them in a convenient location. Like the 1933 Act, the 1934 Act authorizes both civil and criminal penalties for violations of the Act. For insider trading violation, the maximum sentence is 20 years in a federal penitentiary. The maximum criminal fine for individuals for insider trading is $5 million, and the maximum fine for non-natural persons, such as a corporation, is $25 million for insider trading. Both the SEC and individual investors who have been defrauded can sue under the 1934 Act. In other words, individuals have a private cause of action under the 1934 Act. The SEC can seek civil monetary penalties as well as equitable remedies like injunctions. The SEC can also settle with a company and enter into what they call an agreed consent order to settle violations. There are some amendments to the 1934 Act, particularly with respect to insider trading. Under the Insider Trading Sanctions Act of 1984, the SEC can seek 3 times the profit gained or losses avoided for insider trading. Congress also expanded the SEC's authority to deal with insider trading in the Insider Trading and Securities Fraud Enforcement Act of 1988 by subjecting more individuals to civil liability and permitting bounty payments to individuals for whistleblower information on insider trading. Remember, individuals can also sue under the 1934 Act directly. An individual may seek rescission of the contract to buy securities or may recover damages based on the violator's profits. The bigger the company, the bigger the damages. Defendants sued under the 1934 Act may seek contribution for liability for damages from other parties, such as lawyers or accountants, who may share liability for the violation. But the plaintiff can't bring those people in directly. It's up to the defendant to bring those people in as contributors. The next topic I want to briefly discuss is the regulation of investment companies. An investment company is an entity that is engaged primarily in the business of investing, reinvesting, or trading in securities, and that is engaged in such business with more than 40% of the company's assets invested in securities. However, it excludes banks, insurance companies, savings and loans, and finance companies. To prevent the exploitation of small investors, Congress passed the Investment Company Act of 1940. The act was created to regulate the organization of investment companies and the activities they engage in and set standards for the industry. The act clearly defines the responsibilities and requirements of investment companies and the requirements for publicly traded investment product offerings, including open-end mutual funds, closed-end mutual funds, and unit investment trusts. It primarily targets publicly traded retail investment products and regulates U.S. investment companies when offering and maintaining pooled investment funds. Investment companies must file a notification of registration and annual reports with the SEC, and there are limits on how they buy and finance securities. The final topic I want to cover in this chapter are state securities laws. Not only must issuers obey federal securities laws, they must also obey state securities laws, often called blue sky laws, which regulate the offering and sale of purely intrastate securities. Although certain securities like intrastate offerings that we discussed previously may be exempt from federal law, they may be subject to state law. Like federal laws, many state security laws require registration of securities issued in the state and require similar disclosures of information to investors. State law also regulates security brokers and dealers. While state and federal securities laws often overlap, there are differences. To avoid conflicts of laws and federal preemptions, most states, including Kansas, have adopted the Uniform Securities Act. The purpose of the Uniform Securities Act is to deal with securities fraud at the state level and to assist the SEC in enforcement and regulation. Most state agencies believe that they are assisting the federal government, assisting the SEC, rather than leading it. This is the end of Chapter 23.